Hello, everyone. Welcome to another in this series of Chevy Chase at Home Speakers Forums. I'm John Ydstie. I'm a member of the Chevy Chase at Home board. First, today, a quick message about this organization. Chevy Chase at Home engages adults 55 and over in social and educational programming like this event, both in person and online. We also provide volunteer services to seniors who need assistance to remain at home, including rides, tech support, and minor household chores. You may want to consider becoming a member or volunteer if you're not already. One reminder, this program will be recorded today, so it will be accessible on the Chevy Chase at Home YouTube channel. And now to our main event. I have the privilege today of introducing one of the finest American journalists of the past half century, David Shipler. David is a Pulitzer Prize-winning author and former foreign correspondent of the New York Times. He's reported from Southeast Asia, Russia, and the Middle East, as well as from here at home in the United States. He's the author of many books on a wide variety of topics. David, who lives right here in Chevy Chase, currently writes an online column called the Shipler Report and produces a podcast called Two Reporters with my former NPR colleague, Daniel Zwerdling. David has written a series of books about the U.S. Constitution and Bill of Rights and has titled his presentation today, The Dying Constitution. Welcome, David.
John, thank you. Thanks. Well, that was a very nice introduction, I have to say. 50 years. Well, in that case, I have to go back 50 years. First of all, I need to, in the interest of full disclosure, I am not a lawyer. I'm certainly not a constitutional scholar. I'm a journalist. I've been interested in judicial affairs and criminal justice for some time, and I have written 3 books on American rights. The Rights of the People was the first one. I get to hold it up to the camera. The second was Rights at Risk, and the third, Freedom of Speech. I think my interest in all of this was really given a lot of momentum when I was in the Soviet Union in the late 1970s. When you go overseas to another country, you see your own in much more stark and clear form. And I met there an American political scientist who was teaching for a year at Moscow State University. His name was Robert Kelly, and he was having trouble explaining American politics and the system to Russians. He finally started to try to explain it by saying, if the United States has a state religion, it is constitutional democracy. It's an interesting metaphor because as you look around the political spectrum today, from extreme left to extreme right, you do not hear very many Americans denouncing the Constitution. They interpret it in terms of their own interests, of course, in varying ways. But there are very few who want to throw it away, tear it up, burn it, replace it with something different. The Constitution remains a foundation of belief and of authority. And the question is, what does it mean? What does this amazing document have to do with the present, having been written in the 1800s? I think that one of the unique things about the American Constitution, there are quite a few elements that make it unusual and unique, is the fact that it does not have the state giving rights to people. It actually assumes that the people have rights. This is very different from a lot of other countries' constitutions. The Soviet Constitution, for example, really sounded great. It had wonderful provisions in it. They all came from the state. That is, the state was giving rights to the people. One of them was the separation of church and state. I got into a little discussion with my very politically orthodox Russian teacher about this one once, and I said to her, if you have separation of church and state in the Soviet Union, why aren't there any Christmas cards available? Of course, this was the communist days. Religion was quite tightly curtailed and restrained. And she looked surprised at me. The question didn't make sense to her because she said, look, all the state printing plants or all the printing plants are state owned. You couldn't have them print religious cards. That would violate the separation of church and state. A dissident I knew was called in for interrogation by a KGB agent. And when he started to cite the rights in the Soviet Constitution, the agent gave him an indulgent smile and said, please, we're having a serious conversation. So constitutions, certainly that constitution and constitutions in other places, are not as sacred as ours, really. And I think it's important for us to think clearly about what it means in various provisions, how differently parts of this society interpret them, and think about how it survives going forward. You know, on this question of the rights being inherent and not given by the state, all you really have to do is read a couple of the amendments and note the way they're worded. So take the Fourth Amendment, for example. I do keep a copy of the Constitution on my desk for reference, and read it a lot, actually. It's quite a remarkable document. So the Fourth Amendment, listen to the way it's worded. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and so forth. So the rights are the starting point, and they shall not be violated. The First Amendment worded it similarly. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. So the rights are there as inherent. Some would say divinely given. The framers, I don't think we're talking about divine rights, but natural rights, rights that you're born with. And by the way, there was a certain nervousness about listing lots of rights, because what if you left some out? And so the Ninth Amendment takes care of that. It says, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So when conservative justices recently overturned Roe v. Wade, saying there was no right to privacy or to abortion in the Constitution, well, sure, there are lots of rights that are not enumerated in the Constitution. But there are transcendent ideas, transcendent principles that go beyond the moment and are larger than the framers were themselves. I mean, the ideas are bigger than those men were. Many of them were slave owners, for example, and yet what they wrote has been seen to expand and extend the rights of citizens in a much broader way than the framers actually envisioned at the time. Now, you may remember on January 6th that quite a few of the demonstrators who took over the Capitol tried to change the results of the election, and including the president himself. They were talking about defending the Constitution. I would say defending a Constitution they had not bothered to read, because the 19th Amendment is quite clear on what the vice president can do and can't do. I mean, it's if I can find it quickly, I'll just read it to you, and you can see I'm sorry, not the 19th, the 12th Amendment. We're talking about the 12th Amendment, which says, it's a very long paragraph that goes into a lot of detail about how the electoral votes are to be handled and all of that. And there's only one role that the president of the Senate, that is the vice president of the United States, has. The amendment says the president of the Senate shall, in the presence of the Senate and House of Representatives, open all the certificates, and the votes shall then be counted. End of story. So the notion that Vice President Pence had the authority to do something different, I think betrayed the fact that those who advocated it had never read the Constitution that they were supposed to be defending and upholding and citing. Now, this is an interesting area because I think that when you look at the way the Constitution has been interpreted from the time it was created until now, you see a lot of evolution, actually. And the evolution accompanies the evolution of the society. It is not a static document. And that's why I picked this very provocative title for this talk, because you know the debate, you know the difference, you know the polarized discussion about the Constitution. Conservatives deride liberals for embracing a living Constitution. Liberals say to the conservatives that if you shackle the Constitution to the past, its transcendent qualities are stifled. So the opposite of a living Constitution could be a dying Constitution, because if the Constitution remains, frozen in amber in the late 18th century, then what happens as the society changes and evolves? What happens as our sensibilities improve about the nature of individual rights? And in fact, if you look at conservative jurisprudence, it's hard to say that they're being very consistent about it, because they are willing to overturn precedent because they see a precedent as out of tune with today's society and concerns. They certainly are willing to adapt the provisions of the Constitution to advancing technology, and I'll get to that in a moment. After all, precedent is important. Dares decisis is the legal term. It's critical, on the one hand, to creating one of the ingredients of the rule of law in any country, and that is stability and predictability, so that everyone knows pretty well what the parameters of behavior are, what the limits are, what the results will be if you cross a line, and that sort of thing. So precedent is certainly critical, but of course some precedents have to be overturned as the society matures. Korematsu, upholding Japanese internment. In 2018, Chief Justice Roberts, in upholding Trump's ban on immigrants from Muslim countries, nevertheless wrote that Korematsu was, quote, gravely wrong the day it was decided. Plessy versus Ferguson, equal but separate doctrine, overruled by Brown versus Board of Education. Dred Scott, in which Blacks were not considered American citizens, whether they were free or slave, and could not sue in federal court. These are all precedents that denied rights, not those that recognized rights, which makes them very different from Roe v. Wade, which recognized a right. And again, the right that it recognized is not enumerated in the Constitution, but under the Ninth Amendment, probably could be considered to be there. And under the Fourth Amendment, the notion that there is a right of privacy in the Constitution certainly is implicit. It's not mentioned. The conservatives are absolutely right about that. The word does not appear in the Constitution. And yet when you read the Fourth Amendment, which prevents warrantless searches and seizures in most cases, you see a general atmosphere that's being created that recognizes that every individual has a zone of privacy that cannot be violated by the government unless under certain very restricted conditions. Precedent has also been adapted, overturned, however you might say, in the technological area. One of the things I discovered when I was doing research on this, and I spent a lot of time on the Fourth Amendment, because it's a particularly interesting and rather easily challenged set of principles, because there's so many exceptions to it that have been created by case law on criminal matters that it's really pretty complicated now to find the boundaries of what the state can do to undertake surveillance or searches and that sort of thing. But as I was doing this, I discovered that, and then I talked to some lawyers about it, that in 1928, in a case called Olmstead versus United States, the Supreme Court ruled that you didn't need a warrant to tap the phones of, in this case, bootleggers, because the voices were transmitted outdoors, where no search or seizure could occur under the Fourth Amendment. The quote is, "The language of the amendment cannot be extended and expanded to include telephone wires reaching to the whole world from the defendant's house or office. The intervening wires are not part of this house or office any more than are the highways along which they are stretched." This is what's called the trespass theory of searches and seizures. You have to physically be there to violate the Fourth Amendment, or to get into an area that's protected by the Fourth Amendment. Now, that was 1928. Long distance telephone had just been introduced. It was a new technology, but it wasn't until 1967 that was overturned. In 1967, in Katz versus US, the Supreme Court ruled that you did have to have a warrant to wiretap a phone. And by the way, that threw lots of police departments off balance, because they'd been going along perfectly happily, tapping people's phones without warrants. So all of a sudden they had to make a case. They had to go to a judge with an affidavit asserting probable cause that evidence of a particular crime would be found in the conversations that they were going to listen to. And so it created a whole kind of sea change in investigatory methodology, but not till 1967. The courts have been very, very slow to catch up with technology. Just recently, it ruled that to put a GPS tracker on an automobile, you had to have a warrant. There are cell phone cases. There are other cases coming along, actually, that are quite interesting, to raise the question of whether we have the right of privacy when we go online and send emails and that sort of thing. Because the basic concept has been that if you share information with a third party, you no longer have what is called an expectation of privacy. So if you write a check to somebody, that check is not in your zone of privacy any longer. The bank has it, the payee has it, and so forth. So the question of how that extends to electronic information, which of course we all put out there all the time, is one that is in the process of being litigated. You have the ACLU and EPIC, which are organizations trying to enforce or bring up to date the Fourth Amendment, against many law enforcement agencies that don't want to be restricted in what they can do and how they can access information. So it's a very interesting area, and one that's likely to continue, working its way through the courts into the Supreme Court for quite some time. One thing I think we should remember, and it's really important, is that every right that exists that is specified in the Constitution, or I should say recognized by the Constitution, and particularly in the Bill of Rights, has been kindled by its violation. That men could torture other men to extract confessions led to the Fifth Amendment's guarantee that no person, quote, shall be compelled in any criminal case to be a witness against himself. The writs of assistance issued by the British as blanket authorizations in the colonial period for unlimited searches of whole villages led to the Fourth Amendment's ringing declaration about the right of the people to be secure in their houses and so forth, persons, personal effects. Note the word secure. Sometimes people think that civil liberties and security are opposite sides of a coin, that they are juxtaposed against each other. And yet the framers' sense of security was security from the state, security from overreaching government and from state power. So the notions of security, I think, have to be thought about in a very careful way. It's not a zero-sum game at all to have robust protections of rights and security at the same time. There are conflicts, no question, at times, but by and large, the sense of security is built into the Constitution, and particularly most explicitly in that Fourth Amendment. Now, religious persecution, both in England and America, generated the First Amendment's ban on any law respecting an establishment of religion or prohibiting the free exercise thereof. Now, we know, we've seen, we still see all the time in cases that arise that there's a tension between this anti-establishment clause and the prohibition clause. Because how do you balance? If you don't allow the state to establish, how far do you take that? I mean, you have this most recent case of a football coach going out after the game and praying at the 50-yard line, which was seen as somewhat coercive of his students, of his players. And the case, he was fired. Case went all the way to the Supreme Court, and the Supreme Court reversed the lower courts and said, yes, he has every right to do that. That's his First Amendment right, free religion. But isn't it an establishment in a sense when it's a school-sponsored, a public school-sponsored activity? I have to tell you, I did have to wonder if it had been a Muslim who had gone out there on the 50-yard line, put down a prayer rug and prayed in the direction of Mecca, would this conservative Supreme Court have been so accommodating to that expression? Of course, they would like to say yes. I'm not so sure. And so that idea that there could be an establishment of religion when a state institution, whether a school or any other governmental supported institution, permits the expression of religion under its kind of rubric or jurisdiction, is one that's, it's tricky, and we're working it through, and we're not working it through all that well, in my opinion, sometimes. But dogmatism on each side of that question is probably not the first way to go. Our liberties are all rooted in their opposites, as I said, the separation of powers and the autocracy of monarchs, freedom of speech in the press and censorship, the right to counsel and due process in the Star Chamber of the 16th and 17th centuries. And on religion, it's particularly interesting because that came out of a background of raging religious persecution in the colonies. There's a great book on this, which if you're interested, I highly recommend to you. It's by Stephen Waldman, and it's called Founding Faith. In that book, he chronicles the persecutions that were directed at religions of various denominations in various colonies. Virginia banished Jews, Quakers, and Puritan clergy and deported what they called popish priests. The state also required the colony at that point, required Catholics to take an oath to the Church of England before they could hold office. Anti-Puritanism reigned in North Carolina, South Carolina, and Georgia, where the Church of England dominated. In New England, the Puritans and their congregational church were in control, essentially. And there, Quakers were whipped and hanged. It happened in Massachusetts. Massachusetts denied the vote to Catholics, Jews, and other non-congregationalists. And in Maryland, our dear state, which was created as a refuge for Catholics, they prescribed the death penalty for non-Christians. And then when Protestants took power in this state, prohibited Catholic worship of any kind, and sentenced priests to life in prison. So that's the background in which, out of which the First Amendment's protection of religion and anti-establishment provision arose. And it happened for political reasons. There was a congressional candidate in Virginia named James Madison, and he was lobbied by the growing Baptist minority in Virginia, whose preachers had been jailed. And you remember from your history that to get ratification of the Constitution, the Bill of Rights had to be provided. There was just not enough support in the states, in the new states, for that basic document without some clearer, more explicit provisions of rights. I mean, there was a view in the Constitutional Convention that the provision for habeas corpus would be sufficient, habeas corpus being the right of an imprisoned person to sue the jailer to show cause before a neutral magistrate of the reason for being jailed. And that came out of English common law, and it's in the Constitution, but there was a feeling that more was needed. And so you got these amendments. The First Amendment's religion provision was a political act. It was because the constituents were very, very uncomfortable in what was going on in Virginia. So you have this amendment and these provisions growing out of a very kind of a ferment of recrimination and persecution and real religious tension. I mean, there's a view, among some conservatives that America was a kind of a unanimous, homogeneous Christian country. Well, it was not solely Christian, first of all, but also it was hardly homogeneous. It was riven by all kinds of religious tensions and strife. And, in a way, we're lucky because we got this provision out of it. Diversity and clash and conflict actually helped to create a society that whose documents contain these protections of rights. If we had been homogeneous, we probably wouldn't have all of these protections. Now, I want to go to the Fourth Amendment before I stop and open it up to questions or discussion, because I spent quite a lot of time when I was doing my civil liberties book looking at the Fourth Amendment and how the provisions kind of met the street, so to speak, where the rubber hit the road. And I spent time with two police units in Washington, D.C., both of which dealt with issues that were clearly involved Fourth Amendment questions, that is, limits on search and seizure without, and a lot of times they didn't have warrants. So how did that work? I was really interested in and I spent some weeks in the office of the Federal Public Defender in Washington. It's a wonderful group of lawyers who are very skilled. I went to court with them. I looked at the files. They explained a lot of stuff that was going on. And then I spent these many, many nights with two police units. One of them was called the Power Shift, and their job was to get guns off people. And the other was an undercover narcotics unit. So both of them dealt all the time with the questions of when could they search people without warrants. The answer is almost always in certain neighborhoods. A federal district court judge, Paul Friedman, who tried many cases involving gun possession and narcotics, because the federal courts in DC are very different from what they are anywhere else, because DC is not a state. So a lot of street crime goes before federal judges there. So Judge Friedman told me, he said, when I was talking to him about some of these cases and searches, he said, I don't think that there's much left of the Fourth Amendment in criminal law. And that's a federal judge saying that. So what happened? Well, in the middle of the night, less than a 5-minute drive from where Supreme Court justices sit in their rarefied world of abstractions, the power shift was patrolling the streets. And in the summertime, when people were out on the corners, they would go in uniform. They weren't undercover. They had marked cars. They wanted to see the reactions of people on the street when they arrived, because they thought they could tell by little telltale signs who might be carrying a gun. Now, this was before the Supreme Court's decision in Heller, which found an individual right under the Second Amendment to be armed. So any possession of a gun in DC was illegal, any possession of a gun. Now, the court actually in the Heller case didn't really change that much, because what it ruled was that you could keep a gun at home for your self-protection. But they did not rule at that point, and I don't think it's still the case, that open carry without a license was legal. So people had guns on them were violating federal law, period. So what would happen? Well, it was quite remarkable. Young guys, all Black neighborhoods, by the way. This unit didn't operate in Georgetown. I once asked the sergeant, G.G. Neal was his name, who ran this unit. I said, how come you guys don't go to Georgetown? You think there are no guns there? He said, oh, I'm sure there are a lot of guns there. But the difference is they're not shooting each other with them. And if we're in Anacostia or other, Black neighborhoods, he was white, by the way, but his unit was multiracial, mixed, Black, white, Latino. So if we're in these neighborhoods, people know we're there. They might not bring guns out to the street, and they might think twice before when they get into an argument about what to do. And if they're going to shoot somebody, they have to go home and get the gun first. That was his theory. Well, how does the Fourth Amendment stack up here? Because what happened was, as the cops would come in to a neighborhood or part of a neighborhood, and young guys would be standing around the corners or on the streets or whatever, they would automatically pull up their T-shirts to show they didn't have guns tucked in their waistbands. It was a reflex. They didn't even have to be asked. The police didn't have to say, may I search you? Or I'm going to pat you down. It was just automatic. It happened so often. So that's another reason that they didn't go to Georgetown. Can you imagine what would happen in Georgetown if the police came up to a pedestrian or many pedestrians and said, let me just do a quick search, and pat them down without what is required, which is, under the case law, reasonable suspicion to think that the person is armed and dangerous. That's what Terry versus Ohio, an old court case, the seminal case, actually, and a whole line of cases on this required. That is, the police officer has to feel a reasonable suspicion. It's a vague term, but it's a little less than probable cause. A reasonable suspicion that the person he's encountering is armed, and therefore can frisk him without his permission. A lot of the pat downs were done with permission. A lot of the car searches by the gun unit were done with the permission of the drivers. And sometimes I would ask the drivers afterwards, or the pedestrians, how come you let the police do a search? And they'd look at me kind of surprised that, oh, we didn't have to do that. I thought we didn't have a choice. Or some would say, well, if I refused, then they'd really get suspicious and they'd search anyway. So the difference between the Fourth Amendment and the Fifth Amendment in this regard is, you all know the Miranda case, the Miranda warning under the Fifth Amendment, where the police, when they arrest someone, before they question the person, they have to advise the person of the rights to remain silent and to counsel. So basically, it's a Fifth and Sixth Amendment advisory. Sixth Amendment is the right to counsel. Fifth Amendment is the right to silence, and the right against self-incrimination. You're not required to incriminate yourself. And the court ruled in Miranda that the police have to issue that warning. Fourth Amendment case went to the court, and the court went the opposite direction. They ruled that there was no such warning that you have the right to refuse a search that was required. So the police do not have to give you a warning that you have the right to refuse a search. They can come up to you and say, you mind if we just search real quick? And that's what they do. And the narcotics unit does it all the time. They do it with people getting off the train in Union Station. They go up to people, they judge, they make their judgments about who might be carrying narcotics. They ask for permission to search the bag. Many people agree. Sometimes they find drugs. So that's the Fourth Amendment is not as strong as it should be. And the citizenry is not as smart as it should be, because we all should know, it's a part of basic civic education, that we have the right to say no to a search. Show me the warrant. Show me the warrant. Now, there are some searches that don't require warrants. So in exigent circumstances, for example, chasing a perpetrator of a crime into a house, or, there are lots of rules about automobile or vehicle searches based on the fact that the evidence could move and disappear and be taken away. So the police there also don't have to have probable cause to do a warrantless search. They don't have time to get a warrant, so they can use reasonable suspicion or evidence of a crime in plain sight or in plain view. So I was with a unit once, and they saw a car, a very nice looking car, stopped and parked, and the driver got out of the car, walked across the street, and then down the other side of the street. And the Sergeant Neal, looked at this and thought, the guy is moving away from the car a little too quickly. So he got out. He said, "Good evening, sir. May I? Is that your car?" And the guy stopped and said, "Yes." He didn't have to say yes. Do you think we could just take a look? And the guy went, "Yeah, sure." He went back. He didn't have to do that. Then Neil said, "You think we could just could you unlock it for us?" Guy didn't have to do that. He did. At which point, Neil looked at a cup in the cup holder and said, "Is that alcohol?" The guy didn't have to answer, but he said, "No." And he opened the door to show Neil that it wasn't alcohol. And under the cup was a little zip, what they call a zip, little plastic bag, a Ziploc bag of crack in plain view. That gave the police the right to do a warrantless search. And inside on the floor in front of the passenger seat, they found a Tec-9 gun. So that was a case when I said later to Neil, I said, "Sergeant," I said, "let me understand this. He didn't have to acknowledge that that was his car, right?" Neil said, "No, he didn't." "And he didn't have to take you back to it, right?" I said, "No." "Didn't have to unlock the door, right?" "No." I said, "He certainly didn't have to open the door, right?" I said, "No, he didn't do too well. He didn't do too well." But he said, and many police will tell you this, it's the dumb ones we catch. So we have a problem here of sort of a multi-layer problem. We have the courts that are making it increasingly easy, actually, for police to do searches without warrants. And there's a lot of case law on this, number one. We have judges who misinterpret the case law. Justice Kavanaugh, before he was a justice, for example, had a case, and when he was in the DC circuit, and I followed this case and wrote about it in my book, where he completely misinterpreted Terry versus Ohio in order to give the police the right to searched for drugs on somebody who was then tried on the basis of the search. What the search found was a pedestrian, as I recall, and Kavanaugh just misread. Had to be intentional. I can't imagine he didn't know what Terry versus Ohio was about. Terry versus Ohio was about a weapon, not narcotics. And there was nothing in that case that authorized the police to do a warrantless search of a pedestrian based on reasonable suspicion that the person had narcotics. Nothing. But Kavanaugh said that's what it was about. And in fact, he, with that case and others that other judges ruled on similar ways, really moved the goalposts in a way to the point where Terry versus Ohio has become no longer about danger to a police officer, but the search for contraband, the search for criminal evidence without a warrant. So if that's consistent with the Fourth Amendment, then I need some English language training. This is why this notion of originalism versus liberalism, you could say, strikes me as quite utilitarian and not very principled, because there was nothing originalist about that Kavanaugh opinion in that particular case. Anyway, that's basically my talk, and I won't go on except that to say one more thing, and that's to quote a really wonderful poet about the Constitution. He wasn't writing about the Constitution. Philip Booth, a poet who lived in Maine, wrote a lot of poems about being on the water, about sailing. And he wrote one beautiful poem that I think is a great metaphor for the Constitution and how it interacts with reality. He wrote about navigating in the fog and listening to the whistles and smelling the sea off the land, the wind off the land, and all of the cues that you had to use before GPS. And at the end, his final line is that a good sailor knows that the chart is not the sea. The chart is not the sea. The Constitution is not America. We need to preserve it. We need to nurture it. We need to understand it and teach it. So I'll stop there.
Thank you very much, David. Very provocative and illuminating presentation. And I'm going to take the moderator's prerogative and ask the first question. You've been talking about the erosion of rights, the restriction of rights that are choking the Constitution. I wonder if you could comment on at least one amendment where those rights seem to be expanding, and that's the Second Amendment,
Yeah.
where the right to bear arms has become the right to own and carry an AR-15 almost anywhere you want to. What's happening there that is the opposite of what's happening in the restrictions in many other amendments?
Well, I think that's a good point. I probably should have spent more time on that. I think there you're seeing the politicization of the courts, basically. I mean, it's unfortunate, but there's no question that the divide is a political divide between judges who were nominated by Democrats and judges who were nominated by Republicans. So the notion that the Second Amendment confers an individual right is one that was, expressed in that first gun rights case, the Heller case. If you read the opinion, I love reading Supreme Court opinions. Actually, it's not as hard as you might think, especially if you don't go back to all the references of other cases. But if you read that opinion, it was written by Scalia. You see that a lot of it is a debate about grammar, what it was meant at the time by this word or that word, and you had that confrontation between the conservatives and the liberals about it. And I think that, and then both sides brought in the situation in the 18th century, how guns were used, what the extent to which they were allowed, and in the society at large, and so forth. So I think that, and I'm not an expert on the history of the Second Amendment, but it seems to me that just as a layman reading that text and the Scalia opinion, you have to kind of scratch your head. Unfortunately, a lot of Supreme Court justices and judges at the lower courts start at the end of where they want to be and work backwards to justify it. So the Second Amendment sounds to me like it's about a militia, a well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. Doesn't that sound like they can keep their arms if they're part of a well-regulated militia? And now they did that, in those days, they kept them at home, they kept them individually. So if they were called up or mobilized, they had them. They weren't kept in some distant armory. And I think that was one of the arguments. But yes, you're right. That right has definitely been expanded. I might add something about free speech too, because I talked about the religious issue in the First Amendment, but the conservatives on the Supreme Court have jealously protected the rights of free speech, even when they've gone against what we would imagine their political predilections. For example, the right to burn an American flag as an expression of protest, that's protected in Supreme Court case law. I don't know how it would come out now. It wasn't a unanimous decision by any means. The right of the Westboro Baptist Church to protest outside soldiers' funerals by celebrating their death because it was a punishment against America's embrace of homosexuality. That was a more recent case, and that right was upheld. So there are conservative justices who understand that free speech protections are necessary to protect outrageous speech or speech that we all find repulsive. And you don't need the protection if the speech is well within the middle ground of what's acceptable. So that's an area where I think we have not yet seen the erosion of rights. Not yet. Maybe it will happen, but it hasn't happened.
Let me ask our audience if you have a question to raise your hand, and David will pick you out, or I'll try to pick you out of the crowd. I have one more question while you formulate your own. David, you've talked about a dying constitution where rights are being eroded. How do we reverse that? How do we rejuvenate the Constitution?
I think it's a matter of education. Every secondary school in the country ought to be teaching kids about the Constitution and the rights, and also looking at countries where they have been eroded, where countries that have moved from democracy toward autocracy, to see, because when you see that happening, you can see what's happening in the United States. I mean, of course, there's been a great deal of attention paid to the fragility of democracy around the election, the lies about the 2020 election, and the Republican efforts in states to put people into position of power overseeing elections who apparently will not make sure that they are fair and free and correct in terms of vote counting. Although part of me thinks that if a lot of those folks, actually thought that the last presidential election was rigged, maybe they'll be devoted to making sure that the next one is not rigged. And that would be fine, if they come from a different political standpoint, as long as they're fair-minded, objective, and want the actual vote count, maybe we're not in as deep trouble as we thought. But I think, really, I think the state of civic education in our secondary schools must not be very, very high. That's all I can say. And a whole effort is needed to address that. I mean, I heard a talk by Justice Gorsuch a few years ago in which he quoted a survey, and I don't remember the exact numbers, but in which a minority of Americans even knew that there were three branches of government. And then those who did know couldn't name all three of them. And this distressed him, as it should distress all of us.
It leads to successful Senate candidates who can't enumerate all three branches of the government, and they're yet have about not quite a majority of the voters in their state. It's appalling, I must say. You're being very kind, as you should be, but it's terrible. And Heller, I mean, one of the bedrock principles of interpreting a document is, to the extent it is possible, you give meaning to all of the content of the document. And Heller just takes the Second Amendment and takes out what had been thought for 250 years to be a critical part of it. The idea that that's originalism is silly. Thank you.
Yes, well, I agree with you.
Any other comments or questions? Susan?
Wait a minute. Can't,
You're
I
on.
lost everybody. Oh, okay. Oh, thank you.
Sure.
So given that we have a Supreme Court that's going to kind of interpret the Constitution as they see fit, not anyway, I'm worried about the future of same-sex marriage, about birth control, and how can this be considered to be illegal when, and how can abortion be illegal when 50 years ago I was out there fighting with a lot of women my age, fighting for the right to abortion? How can they just walk away from this?
Today we have discussion group.
Well, I mean, I think, well, you,
5 o'clock.
what their argument was in Hobbes, the recent case, that
Hold on a moment,
sorry,
David.
somebody's,
Hello,
Yeah, just a minute.
someone is talking, and you need to mute your microphone if you want to talk during David's answers or the questions. Thank you. Go ahead, David.
well, of course, the conservative majority on the court in Hobbes, the recent case, found that Roe was wrongly decided, that it was not based on anything in the Constitution. For a long time, conservatives have argued that there is no concept of privacy in the Constitution. As I mentioned earlier, the word does not appear, in fact, and that certainly abortion is not, there, and that when the Constitution was written, that generally abortion was not considered legal. So they're trying to kind of turn the clock back a couple of hundred years to use both the words and the kind of atmosphere at the time to justify what is their view on a particular social issue today. And that's where I think it's really dangerous, because you can have huge, dramatic pendulum swings in basic constitutional interpretation based on the whims of justices who happen to be in the majority or the minority at different times. And that is not a prescription for the rule of law. The rule of law requires a certain stability and predictability, as I mentioned. In fact, the American Bar Association some years ago created a project called the World Justice Project, in which they analyzed the state of the world, the rule of law in countries all over the world. They worked, I was kind of involved in the initial meetings on this. And one of the topics that we discussed was, what are the definitions of the rule of law? What are the characteristics of it? And that respect for precedent was definitely, and stability and continuity was definitely at the heart of it. So when you don't have that, and we don't now, unfortunately, to the extent we should, it's very disorienting, I think. And you've seen, I mean, it's thrown the country, into an uproar about it. It's had an impact on the recent elections and so forth. And so, and the Supreme Court, the conservative Supreme Court, was chipping away at Roe anyway. Most people, I think, expected them to do some more chipping rather than just throwing it out the window. But you have very, very extreme right-wing justices now in the majority. So thanks to Mitch McConnell. So that's the problem. Now, the other rights that you mentioned were mentioned by, I think, Thomas in a concurring opinion, and maybe Alito. That is the right to contraception, gay marriage, and so forth.
Thomas,
I can't predict. I'm not, when I worked for the New York Times, I was under the strong impression that I was never to use the future tense. So I'm going to stick with that now. I won't predict. I'm just saying, have this feeling that might, having created an uproar with this Dobbs case rather, overturning Roe. There are a couple of conservatives on the court who might not go as far as Thomas and Alito might want to go on gay marriage and contraception. I'm hoping that Roberts can hold sway. I mean, there is a view that Chief Justice Roberts, cares about the legitimacy of the court. I'm not sure about that. I don't know where they get that from, but anyway, people who have talked to him, I guess, have picked up on it, that he's concerned. And he apparently tried to temper the Dobbs decision so that it wouldn't throw Roe out the window. But who knows where they go from here? I mean, it's a question. I mean, it's not a happy time in terms of jurisprudence, I don't think. And I wonder myself, and I haven't looked into this, whether liberal groups that lose in the lower courts might be reluctant to appeal to the Supreme Court lest they get a very broad, sweeping opinion that will be extremely damaging overall. So, it could be that you get less litigation put forth by liberal interest groups and parties because they're afraid of the results. And by the way, I might add another thing, which is that I've been told that in the district courts, not the district courts, the circuit courts, courts of appeal, there are some judges who are writing their opinions in a somewhat defensive way to try to avoid a Supreme Court review that would do a lot of damage in a particular area. So this filters down even more subtly than absolute precedent would. So if there are lower court judges who are looking over their shoulders, in effect, at this very conservative Supreme Court, they might be less bold in ruling for a liberal or progressive viewpoint, for fear that they're inviting a disaster up the line.
We have a comment in the chat room. Let me read that to you from Karen McTee Musel. She says, "Thank you for a fascinating discussion, but it fills me with some despair about the value of the Constitution to protect and preserve citizens' rights. It seems you are arguing that justices can and do ignore what is in the Constitution, and that protections in the Constitution can be undermined by practices that get citizens to conform to invasions of public rights, like young men who lift their shirts. What is your advice about what American citizens can do to preserve the best part of the Bill of Rights?" I guess you've commented on that a bit, but any more thoughts on that?
Well, I think certainly civic education, but also supporting organizations that do litigate. I mean, I think, I give money to the American Civil Liberties Union because I believe strongly in what they do. They're quite nonpartisan. They've defended violations of people on the right as well as on the left. So they transcend politics, or try to. there's some debate inside the organization about that, but nevertheless, I think it's a good one. Organizations that try to teach these issues in schools, the Anti-Defamation League of B'nai B'rith, the Southern Poverty Law Center, throw light on patterns of discrimination and prejudice, which of course involve, not so much, not necessarily all, court cases, but societal problems that need to be addressed by good thinkers and people working for the common good. And of course, voting, it's important to vote your conscience and look at the issues and not just the personalities. So all of that is, adds up to citizen engagement in these issues. And I think that we've seen some of it lately, actually. I'm not dancing in the streets about the election, frankly, like some of my friends are, but because I think we have a long way to go before we're out of the woods here. But certainly it was encouraging to see the high turnout, and also relatively high turnout, although that too we shouldn't get that ecstatic about. I heard an interview where someone was rejoicing that the turnout of 18 to 25-year-olds had really spiked. It was 27%. And I thought, well, let's see now, would we be cheering if nearly 73% of young adults were found not to be able to read? I don't think so. So I'm not cheering about that, but I think that tells us how much work has to be done. So, but nevertheless, it was encouraging that democracy and the health of democracy was, were there as an issue of concern. As far as evading the Constitution, well, and evading court decisions, there's a big gap between the Supreme Court and what happens 5 minutes away from them on the streets in the middle of the night, no question. And it's one of the dangers of what's happening in this country, I think, is the profound disrespect for institutions and the lack of voluntary kind of, you could say, acquiescence or accommodation to the rule of law and respect for it. So, for example, I would anticipate, for example, I may be wrong about this, that when the Supreme Court eliminates race as a factor in college admissions, which it's poised to do, the oral arguments took place, a week ago or so, I think there'll be colleges that will evade that. And it's not hard to do. There are lots of factors in admissions, and they're not objective. And as colleges reduce their reliance on SAT scores and so forth, which many of them are doing, the more subjective characteristics of an applicant will gain more and more weight. It will not be difficult for colleges to continue to consider race in admissions if they want to. Supreme Court doesn't have any divisions. It's like what the Pope. How many divisions does the Pope have? The Supreme Court can't enforce the law very well. Doesn't have its own police force. All it can do is rely on the goodwill of the American public to respect the decisions of the court, and to go along with them and to understand them. They have to be explained, and they have to be seen by the public as being based on true consideration of the legal and judicial factors. I mean, I have a friend who's a judge, and he tells me that there are times when he's a lower court judge. He tells me there are times when he would like to see a case go one way, but in fact, the law restricts him and he has to rule according to the law. He has an expression, and I don't think it's unique to him on the bench, that if he sits down to write an opinion that doesn't really conform with what the law should require, he says the opinion won't write. It won't write. And that's exactly what we want in judges and in justices, it seems to me. People who are faithful to the tradition of the law and the Constitution and the way it's been interpreted, which does evolve over the years, not people who come in with their own personal predilections and then rationalize them as they write their opinions.
David, I have one last question from off camera from Mary Jo, my wife, who's sitting here in the same room, but off camera.
Hi, Mary Jo. How you doing?
She wants to know, David, do we need to enlarge the Supreme Court to get a broader and more vital interpretation of the Constitution that reflects more the political views across the spectrum in the United States?
Well, that's a question that's being kicked around, to enlarge the court or impose term limits and that sort of thing. I mean, the trouble with enlarging the court is that, if the Democrats do it, then when the Republicans come in, that they'll enlarge it again, and then so forth. You'll have an arms race, it seems to me, where each side, gets its own justices until it gets kind of out of hand. I mean, it can be done by law. I mean, the Constitution does not specify the number of justices. Probably a better approach, if you're going to make changes, would be term limits. And there's a debate, I think, among people who understand the Constitution of whether that can be done with legislation or whether it would have to be a constitutional amendment, which you won't get. I mean, the Constitution does say, as I recall, that judges will serve as long as they display good behavior or something like that. So that suggests that they can't be told, well, after 10 years, even if you're displaying good behavior, you have to leave. I don't know. That would probably be a contested issue, but that might be a better solution than expanding the court. That's my feeling. Just because then you'd have some turnover, you'd have a sense that there are different administrations over time. If you had a regular expiration date and so forth, would have, each administration would have X number of appointees. But by and large, the court reflects our polarized politics. I mean, it used to be that this didn't happen. I had occasion at a luncheon to ask a Supreme Court justice whether he thought that the court, I said there seemed to be some concern about the legitimacy of the court. Did he think that the court was reflecting the political polarization in the country rather than transcending it? His answer was that he had lunch with liberal justice a lot, and they were really good friends, and they told jokes to each other, and that was his answer. He said, no. He said, no problem of legitimacy. Now, this was before the recent term, but nevertheless, I think that there is anyway, that's about as far as I can go. The problem is, the judiciary committee hearings are dog and pony shows. The senators try to get sound bites on their local TV news. Some of the questions are very serious and well thought out and probing. The justices or the judges to be are not going to answer any questions substantively. They dissemble when it comes to stare decisis, as we've seen. They're talking about precedent and how much they respect it, and then they go and sweep it away when they don't like the case. So, some people think that some of these recent nominees could be charged with perjury since they're under oath when they testify. Kavanaugh, Gorsuch, maybe Amy Coney Barrett was a little maybe not quite there. She was a little, evasive. But Alito, you remember, you probably just read Ted Kennedy's diary has, some notations about how Alito basically promised that he would never overturn Roe. That was a well settled precedent and so forth. So they'll say anything to get on the court and then do what they want. It's debased the institution, I'm afraid.
We'll take another last question from Susan Kahn.
Hi, thank you very much for this talk. I was concerned about my right as a person to have medical care. And I'm really concerned about the changes in the ideas or rulings related to the right to have the abortion procedure. And I'm wondering if that can be defended in any way based on a basic right to medical care and kind of discrimination against a patient based on gender or social stereotypes about how I would choose to use that procedure in my life. And I'm just kind of concerned about my basic right to medical care and my basic right to control my body, have medical care, as well as to be able to make a decision about my medical care in privacy with a doctor. And I'm just wondering if there's anything about discrimination against me as a person who would have a basic medical procedure that could be allowed to be defended or right.
That's an interesting way to frame it. I don't know that I've seen that argument. The 14th Amendment provides for equal protection under the law, and you could maybe make that argument. Perhaps that was in one of the briefs in Dobbs, I don't know. But I think the conservatives on the court would say, tell me where in the Constitution it says that you have a right to medical care. It ain't there. But remember the 9th Amendment, just because it's not there doesn't mean it isn't a right. So at some point, someday, with the right alignment of justices on the court, maybe somebody can make that argument in a successful way. It's a good point, I think.
Well, David Shipler, thank you so much for spending this time with us and providing such an interesting, illuminating, and timely presentation. And thanks to all of you out there on Zoom for being such a good audience. This has been another installment of the Chevy Chase at Home Speakers Forum. We hope you can join us for our next forum in December with attorney Barbara Mulitz. She'll be talking about elder financial abuse among the fastest growing crimes of this century. I invite you to explore other programming listed on our website and to consider joining your local village as a member or as a volunteer. Join us again next time and enjoy the rest of your day.